The traditional litigation expense model is one in which there's very little money spent on the front end, and then almost immediately once the case is filed, there's huge expenses associated with e-discovery. I'm sure if you've been in any kind of litigation, you've gotten the first sticker shock bill after the first document collection went through and the first batch of reviewers came back, and you found that the cost had just skyrocketed, but now you're already in it and you don't know how much more this document review is going to take. Experts can be expensive, trials are obviously very expensive, and so it's another reason to address these things and not just take them for granted, but to try and figure out, is there ways that we can adjust this matrix, and when are these expenses going to hit? So I know that in 2 quarters, I'm going to have a huge bill for this fee, or in a year, we're going to be hiring experts and they're going to want X amount of dollars. That can help you from a planning perspective as well.
So this goes back to ECA, and we say the way you change the playbook is you invest more money in that investigation at the beginning. I mean, we as lawyers, I've been doing this now for 30 years, we as lawyers have been sitting in these depositions and you're thinking, this is just a waste of money for the client. If I had known more at the beginning, I wouldn't have had to do all this discovery in the deposition phase. There's a lot you can accomplish at the beginning to save money here at the back. So, I mean, it's just a plug to say, again, plan ahead. That's the title of our talk today. It's determine where you're trying to go. And even though there may be a knee-jerk reaction, which is there's a new claim, I don't want to spend money either prosecuting it or defending it, I don't want to do it, I'm going to say resist the impulse to spread it out, because there's just built-in, as Jason is saying, built-in inefficiency to go down this road without a plan. If you don't have a plan, then any road will take you there. So I'm not saying that this will accomplish everything, but doing an ECA lets you know this is a case we can win, and here's a range within which, unless things change, unless some new development takes place, here's a range of recovery. So you develop in your initial stage what the plan is for the case. Is this a case we need to try? Who are the key witnesses? Where's the key law? Maybe you can get a summary judgment motion instead of being filed down here. Maybe you can file it right at the beginning. So I'll just give you an example of a case that ultimately resolved very favorably, a very large case. We were hired in a case in which we represented the beneficiary of a trust. It was a business divorce case, but it would involve family issues. And the beneficiary of the trust brought the lawsuit because the trustee had made loans to himself out of the trust, which is a violation, as you might expect, of the trust code. However, the trustee had repaid to the trust all the amounts that he had borrowed. Well, our position was, and under the law was pretty clear, which is if you borrow money from a trust in violation of the trust code and you pay it back, you have to pay it back at the highest legal rate of interest, at 18%. So he had paid it back, but not at 18%. Why 18%? Why the highest legal rate of interest? Because otherwise you're negotiating with yourself an interest rate. You're the trustee, you're the borrower, and the lender. The only way to know that you've treated your beneficiary fairly is to have paid it back at the highest legal rate of interest. So we filed a summary judgment motion and said, there's been a breach of fiduciary duty. Judge, please grant summary judgment. We don't have to have a trial. Hold the trustee liable for breach of fiduciary duty. The other lawyers came in and said, and this is at an early stage of the case, and the other lawyers said, well, Judge, we don't know what the damages are. You can't decide that now. And the judge said, no, under Texas law, you can actually, I'm going to reserve damages for trial. But your guy breached his fiduciary duty. So now they're going to trial already with a finding of breach of fiduciary duty, and the case settled at that point. So my point is, if you determine a strategy at an early stage, it can save you a lot of money and ultimately get you to where you're trying to go.